appreciate the time to speak on this bill, and it's a short bill, 7 parts, 12 sections, 14 pages. It's relatively short, but it covers a huge area in terms of the amendment to different acts, the Immigration Act, the Judicial Council Act, the Firearms and Offences Act 1990, then this miscellaneous amendments that I've no difficulty with in terms of typographical errors, but it also affects serious, the European arrest warrant and criminal justice, mutual recognition of custodial sentences. So there's a lot of legislation being amended, and then we have the superannuation section in relation to extending the age up to 62, which I welcome. I welcome that. I would like to agree with my colleague, Deputy Pringle, in relation to the manner in which this has been done. It's called the Court, Civil Law, Criminal Law and Superannuation Miscellaneous Provisions Bill. And it has been rushed through. I know you've shaken your head, but it has been rushed through. There's been an abridged pre-legislative scrutiny. There was a briefing from the Department of Justice. I understand my colleague here raised concerns, as did organisations, but no other member in relation to this. And that's perhaps why the government thinks it hasn't been rushed through, but it has. And I want to thank the Library Research again for their wonderful documents. And the 24th of June, and they do a note on that, and they tell us this note will not address the provisions of a bill in detail due to the limited time between the bill's publication and the second stage debate. Now, I don't sit on the Justice Committee, so I'm utterly reliant on what the Library do, as long with my own reading, and they're telling us that. They're telling us they didn't have enough time to go through it, and they produced this other one in relation to designation of UK as a safe country, which I'll come back to. And you know, it's more than ironic that we're rushing through this, and this bill, plus the amendments that are to come, that we have no idea of the detail of those, happened because we rushed other legislation through. And so we had a High Court case and a Supreme Court case, one finding fault with the quantum, the level of quantum and the new guidelines that were brought in, which I'll come to. So now we're trying to rectify that in this. And then the other one is in relation to the judgment in relation to designating United Kingdom as a safe country. And again, a failure, utter failure on these various governments to empower when the head shake, it's difficult to continue, but you can disagree with me perhaps in the end and pick me up rather than the body language, because it is difficult. And I'm going to quote from the judgments. I won't use my own opinion at all in relation to this. And so it also feeds into a narrative, Minister, that I'm most unhappy about we'll increase the fines for those carriers that are carrying people, bold people, not people who are fleeing war and persecution, but we're feeding into a narrative which is very wrong. It's just wrong. We're all dealing with it on the ground, and it's just shocking that the government would feed into that narrative, and I don't agree with that. And then we're now going to come forward with amendments. I don't know, for example, in the heads of the bill, I think there was a proposal that barristers would be able to deal with appeal cases after 2 years. Personally, I wouldn't agree with that. I don't know whether you're progressing with that or not. I don't see it mentioned anywhere here. But I see a whole list of things you want to bring forward down here. And it's very difficult to look at this and do this type of reading, which is my duty as a parliamentarian, but to not know what amendments are coming through, particularly in relation to the safe country, where we've been utterly castigated by the court in relation to our failure to empower a minister to carry out the duty properly, to examine case by case before we return anyone to a safe country. We've utterly failed to do that. And we're going to do it by way of amendment, which to me is just not acceptable at all. And again, as my colleague said, in July. So we're increasing, and I welcome that we're increasing the number of judges to the Court of Appeal from 17 to 18. But again, in relation to other things, and thank you to the Library, again, we're aware that there was a phase 1 and there was supposed to be a phase 2. The government were supposed to carry out a review of phase 1 in relation to the number of judges. The plan was laid out. There's not fitting in. There's no context here. We're going to increase it to 18 because justice and power has been moved to the Defence Forces, and I wish her all the best. But no idea where the second stage announced by the government to increase the number of sitting judges. And of course we have huge delays. We've absolutely huge delays, and later on tonight, Deputy Daly and myself and another deputy will be raising the strike or the action being taken by the barristers, most reluctantly. And I can say that someone that doesn't have a conflict of interest, because I left the profession, if one can ever leave the profession, in 2016. And they're being forced to take action that they don't want to take at all tonight because of being underpaid. So barristers, who we rely on with solicitors, and then the judges, not enough of them. And yet we're putting an emphasis on the bold people fleeing war and putting the blame on them and other things. So I'm very wary of narratives coming from governments to suit their own purposes. I won't go into the details. They've already been outlined by Deputy Howland and other deputies in relation to the numbers required. And this part 4 of this one is looking at the amendments to reflect the Supreme Court judgment in the Delaney case. And what did that tell us? What did that Supreme Court tell us? The court upheld the constitutionality of the guidelines, which you welcomed and I welcomed. They upheld the constitutionality of it. But the majority went on to say Section 7(2)(g) of the Judicial Council Act, which empowers the Judicial Council to adopt personal injury guidelines, was a non-constitutional interference with the independence of the judiciary. And that's fairly serious, isn't it? And while you, and if I was in your place, I'd be welcoming the fact that they upheld part of it. But that's a serious statement, interfering with the independence of the judiciary. And surely that's our role here when we look at things, to reflect on what's happening. And we can't do that in this rushed way, although it doesn't seem very rushed now with an empty doll. But in the process, we have a library telling us they didn't have enough time. And so we're now going to rectify that for all future amendments. I'm not quite sure how that happened, although I heard a reference earlier on by Deputy Howland again in relation to at some stage the Dáil seemed to have approved the guidelines, and so therefore that gave the authority, I think. And from now on, we will have to approve any changes to the guidelines. But you'd imagine that would be a notice of caution for us to sort of reflect, use the pre-legislative scrutiny, examine. I can't imagine how that's not been done. And then we have the firearms and offensive weapons. Again, I welcome that to an extent. I welcome that. But again, there's a great absence of statistics. The library have given us statistics for the amount of knives confiscated. And of course, there's a difference between holding a knife, possession of a knife, and a possession of a knife with intent to use it. So I welcome to a certain extent that we're putting a very serious emphasis on those type of crimes, and we're increasing the penalty. But none of this can ever be looked at in isolation without looking at what Deputy Daly mentioned earlier in relation to restorative justice. And all the time we seem to be talking in a vacuum and feeding into a narrative that people have to be punished. I'll be the first to want someone punished for using a knife. I'm not making that point. I'm making the point that it must be discussed in a greater context. Our prisons are overwhelmed. We have them constantly telling us that our prisons are overcrowded and overwhelmed, and we're not putting the same emphasis at all as we are on increasing penalties without statistics to tell us whether it's effective or not, and no emphasis at all on restorative justice or taken other ways. And for example, later on tomorrow, I'll be coming back to that horrible word, domestic violence. I'm not using it anymore. Violence is violence. And in relation to that, we've never looked at the perpetrators as to why they continue to perpetrate this type of violence. Notwithstanding, back in 1997, the Interdepartmental Task Force said we needed to look at the perpetrators. If we look at the finish on the designation of the UK as a safe third country, and this has never been done. It's the first designation, Minister, isn't it, that we've designated a country as a safe third country, as distinct from safe countries of origin, which is a different concept. And so we've designated, and what have we been told by the A and B case, as it's known as, that designation was unlawful and ultra-virus. Unlawful and ultra-virus. And they go into great detail, and again the library goes into great detail, and the judgment goes into great detail as to why that was unlawful and ultra-virus. It tells us a lot about England and the Rwanda, what started off as a partnership and then became some sort of treaty. It tells us a lot about England, and hopefully if the government, then the election, votes in a different party, we might have get rid of that pact. I live in hope. But in relation to what we've done as a country, we've allowed successive ministers to function without empowering them through legislation to analyse each case by case. And while the judge pointed out that you're under an obligation full stop to disallow any national legislation that's not in keeping with our European obligations and our international obligations, she also went on to say that we need to enable the government to carry out the onerous obligations on them under international law and European law and the European Convention, and that each case, before we return a human being, that we analyse case by case, and that there are protective guidelines and protective criteria set down. So we're going to now do that by amendment. We've no sight of that amendment. We're going to rush it through next week. You can see our frustration in relation to this. I want to work with you. I want to empower you to ensure that you're able to look at each case to make sure on a case-by-case basis, and also on a continuum basis to ensure that the country designated as a safe place continues to be a safe place. So there's ongoing obligations. That's what the court has told us. So we have a Supreme Court case and a High Court case in two separate areas telling us that we've utterly failed. And instead of sort of reflecting on that and bringing forward miscellaneous amendments in the true sense of what's miscellaneous, the correction of errors and so on, instead of that, we're going to bring in amendments next week that are seriously important following the case and the outline by the judges. One, we've tried to do it in this, and the other is next week, amongst other amendments that I read for the first time in your speech, and there's a whole half a paragraph on it here in relation to the amendments that you're going to introduce. I don't think that's a way to do business. While I appreciate, Minister, that you might be under pressure, I see no pressure in relation to this. And bringing forward a bill and not bringing forward the main substance of that bill only through amendments is simply unacceptable.